very warm welcome to lesson number 16 in our 50-part series on the law of evidence. In today's lesson, we will discuss res gestae. Res gestae is a concept that is contained in section 6 of the Indian Evidence Act, and we will learn this over the course of this brief lesson. We will have a look at section 5 before we go into section 6. Now, section 5 gives you the fundamental principle regarding the relevancy of facts, right? What it tells you is that evidence can be given only for some kinds of facts, right? And those facts are facts in issue and such other facts that are declared to be relevant. So section 5 gives you this very important rule relating to relevancy of facts, which is that evidence can be given only for facts in issue and for relevant facts. And what are relevant facts? Relevant facts are those which are declared to be relevant, right? So it says hereinafter declared, which means that in the sections that follow it, which means section 5 says that after section 5, you have those sections which declare a fact to be relevant. So we are looking at the chapter 2 from section 6 to section 55. So as you can see, section 6 is one of those sections which declares something to be relevant or irrelevant. We'll have a look at section 6. Now, again, before we look at section 6, we need to have a look at section 3, which contains the interpretation clause. So section 3 is the interpretation clause. Amongst those, you have the definition of the word relevant. Now, what is the meaning of relevant? I want you to look at this word closely. Section 3 says that one fact is said to be relevant to another fact when one is connected with the other. There's more to it, but I just want you to first pay attention to this part. One fact is said to be relevant to another fact when it is connected. And let's go ahead and see the remainder. When it is connected in any of the ways referred to in the provisions of the Act relating to the relevancy of facts. Which means when one fact is connected with another fact in any of the ways that are given in the provisions relating to relevancy, largely from section 6 to 55. So section 3 tells you what it is to be relevant. Relevant means one fact is said to be relevant to another. You know what this tells you about relevant? It tells you that relevant or relevancy is a relationship. For example, if I use the word less, now you cannot say something is less. You have to say less than something else, right? Similarly, brother. Brother is a brother of someone else, right? That means when you say he is a brother, it means you're thinking of him as a brother of someone else, right? So relevant and relevancy also always presupposes a relationship between one fact and another fact. Remember this. And these are connected by a relationship. What is the relationship? It is the relationship that is given in any one of the provisions of the Act relating to relevancy. Simple. Now let's go ahead and look at section 6. In fact, before we look at section 6, I would like you to have this concept cleared in terms of this diagram. As you can see, let us say we are talking about relevancy, right? So when we talk of relevancy, we mean to say that one fact is connected to another fact, right? That means there is a relationship, right? And those relationships are given in the provisions relating to the relevancy of fact. So we understood this by now, and that section 6 will also follow the same template, right? Section 6 will give you one fact, another fact, and a relationship. So we know what to expect in section 6 because it is a provision relating to the relevancy. It would contain one fact, it would contain another fact. This one fact would be declared to be relevant and it will give you a connection and a relationship. This is what section 6 will do for you, right? And this is what every section which deals with the relevancy of facts would do. Now that we know the structure of section 6 and what it will be doing, I want to introduce one more concept to you. You see, in the dispute, the main disputed facts are the fact in issue, right? The factum probandum, the main principal reasons for which the dispute exists. So if these facts in issue are settled, the dispute gets settled, right? However, in order to find out whether the fact in issue exists or does not exist, we need to look at some more facts. And these facts are relevant facts, right? So they are connected with the fact in issue. So you decide the relevant fact and then you proceed and then decide as to what the facts in issue are. Now, these relevant facts in turn may require to be known by some other relevant facts. So you branch out even further, right? And these in turn may be required to be known by some other relevant facts, right? Similarly, let us say we again have another relevant fact which is connected to the fact in issue. We need to know some more relevant facts to know it. In turn, we need to know some other relevant fact to know this relevant fact, and this goes on, right? Of course, you cannot take something which is not connected. Like let us say I put a fact here. Now, if I have a fact here, I cannot call it relevant unless there is a connection. And these connections are given by the sections between 6 to 55. Which means if there's a fact, now the fact is here. If you can find a connection, then it becomes a relevant fact. If there is no such connection, then it is not a relevant fact. This diagram in fact summarizes all of how relevancy works for you. So if you can find any such relationship which is given in a section between 5 and 55, then that fact becomes relevant. If you do not find such a relationship, the fact remains irrelevant and therefore evidence cannot be given for it. Let me explain this with a picture to you once again. As you can see, this is a tree. So this is the bark of the tree, or the main trunk of the tree, the one that is connected to the roots, the main thing. You can think of this as the fact in issue, right? This is the principal fact. However, you also know that these are also parts of the tree as you go further away. So let us say if I talk of this part, which is the trunk, this is the fact and issue. Now as I go further away, let us say I take this point here. Now this point is connected with the trunk in some way, and therefore this would be a relevant fact, right? It has gone away from the trunk, but still it is connected with the trunk, it is connected with the fact and issue. It's a relevant fact. Likewise, if I now take this point here, this has gone further away, yet it is connected, right? It is connected to the trunk through a certain route, and therefore this is also a relevant fact. Therefore, what the rules of relevancy and what the sections relating to relevancy do is that they make certain distant facts relevant. As you can see, these facts here, these are a little distant. However, they are connected and therefore they continue to be relevant. So you can think of it like this. The provisions relating to relevancy make some distant facts relevant so that you can decide the fact in issue, and after deciding the fact in issue, you can decide the dispute. Think of it like this. You have a dispute as the main question because of which people have come to the court. The parties have come to the court. After this, you decide what the facts in issue are, right? In the case of a criminal trial, you frame the charges, and in the case of a civil, it's a framing of issues. Thereafter, to decide these facts in issue, you look at relevant facts. Then you decide the relevant facts, then you work backwards, decide the facts in issue, and then finally you decide the dispute. This is how the process functions. Now, this is the right time to look at section 6. And I want you to pause the video for a moment and read this and try to make sense of it by your own self. Do not listen to my explanation without giving it an attempt by your own self. So section 6 has to follow our template. Like we saw, it contains one fact, right? That one fact is made relevant by section 6. In other words, section 6 declares that fact to be relevant. If you recollect, section 5 said that the sections hereinafter will declare facts to be relevant. So section 6 declares one fact to be relevant. It is made relevant by section 6. Then there is another fact. What is the another fact? That another fact is something which is mentioned in the provision itself. Now that we've understood this structure, let us look at it in some detail. You see, section 6 talks about the relevancy of facts forming the part of the same transaction. So you see, if you have to identify as to what those three things in here are. The first, facts which though not an issue. Facts which are not an issue. You know what that means? This is the one fact or the first fact. What are these? Facts which are not facts in issue. So facts though not an issue means facts which are not an issue, which means facts which are not facts in issue. Facts other than facts in issue are so connected with a fact in issue. So you see, this is the second type of facts in this. Like I said, you have the one fact, then you have another fact. So in this case, the another fact is fact in issue. Here, one fact is that which is not a fact and issue. Okay, so you've got the one fact, you've got another fact, and now what do you need? You want the relationship, the connection, and here they are connected so as to form a part of the same transaction. This is the relationship which connects these two facts that we have seen. And then it says facts which, though not an issue, when they are connected with the fact and issue so as to form a part of the same transaction, they are relevant. Simple. Now, this begs the question as to what a transaction is, right? Because once you understand what a transaction is, then you've understood section 6. If something forms a part of the transaction, then you know that that fact forms a part of the transaction with the fact and issue, and this makes the fact relevant under section 6. So just have a look at what a transaction means. Pause the video and read it. Simply stated, a transaction is a group of facts which are so closely connected that you can refer to them by a single legal name, right? You can refer to those facts by one phrase which collectively speaks of all of those. It's a transaction. Pause the video and read what you see on your screen. Now, what section 6 basically tells you is that every fact which is the part of the same transaction with the fact and issue becomes a relevant fact. So let us say this entire thing of 5 steps is our transaction, right? It's one little process, right? Starting from here and going here, it's one transaction. Let us say this is the fact and issue. This is another fact, this is another fact, this is another fact, this is another fact. Now, since all of these form the part of the same transaction, because of section 6, each one of these also becomes relevant, right? Because they are a part of the same transaction. Let me give you some examples of what have been held to be transactions by the court. All right. So as you can see, pause the video and see this by your own self. This is a case wherein the statements made by bystanders. So something is happening and there are bystanders and they say something. It's a part of the same transaction because they're very closely connected. Section 6 makes statements made by bystanders relevant. Okay. Likewise, you can look at this case as well. Here, when someone who is watching screams out, right? So suppose somebody is being murdered and somebody screams out. What he screams out, that statement becomes relevant because it is a part of the transaction, because it is so closely connected with the fact and issue. What is the fact and issue? It is perhaps the injury or the murder of somebody. Someone else screamed. Now, did that happen as a part of the same transaction? Yes, and therefore it is relevant. Make sure you pause the video and read this by your own self. Now, although section 6 requires things to be a part of the same transaction, it is not required that these be at the same time and place. Have a look at section 6, it makes a mention of this point, right? I had not addressed it earlier, I'm doing that now. What that means is that if something forms a part of the same transaction, it is not necessary that those facts need to be at the same time or at the same place. What we see is, can we call all of it by one common legal term? Does it look like one transaction? You can have a look at the illustration C that is given to section 6 and it tells you this. Let us say there is a suit for a libel. A libel is a kind of defamation, right? So now there is A and B, okay? A and B are sending letters to each other. A sends letter to B, B sends letter to A, and this happens again and again. Now, these two people might be at different places, right? Perhaps there is an interval of 2 or 3 days between each letter. However, there is a conversation from A to B, and then there's a reply from here, there's a message from here, a reply from here. This is a transaction, although it is not at the same time or same place. It's an important point for you to understand as to what a transaction is. Now, not everything is a part of the same transaction. Let me give you an example. You can read this. This is an example of a case where there is a phone call, right? Now, it's not necessary that the phone call will not be a transaction. Suppose the phone call happens instantly, immediately. Let us say somebody is being murdered and someone makes a phone call. At that time, it forms a part of the same transaction. However, the phone call referred to in this particular example is not a fact and issue because it does not form a part of the same transaction. So you can look at this, you can look at more examples to know as to what a transaction is and what a transaction is not. And by the end of that, you'd have a fair idea of what is contained in section 6. We will conclude with a little Latin. So as you might remember, I'd spoken of the word res gestae, which is the Latin phrase which basically means things done or spoken during the course of a transaction, and therefore you can say that res gestae has been embodied in Section 6 of the Indian Evidence Act. So I hope Section 6 is clear to you and this lesson was of use to you. Thank you so much for your patience. Good day.